Welcome to In the Name of the Law, with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinas from Sinas Dramis Law Firm, Amy Bailey from Bailey and Terranova Attorneys at Law, and Mary Chartier from Chartier Nyamfukudza PLC. Now, let's discuss some remarkable stories and real cases.
Hello, I'm Lisa Speaker with the Speaker Law Firm. Today we're going to talk about when tragedy strikes and how to navigate these life-altering situations. Stay tuned.
In the name of family law.
Good morning, Amy and Erica, both from Bailey and Terranova, family law attorneys in Okemos, Michigan. We're talking about a serious topic today about when tragedy strikes families. So a lot of families live in different households because they've been through divorce or they weren't married. What happens when something terrible happens to one of the parents, maybe, and they pass away?
Lisa, that's a very, very good question because it can happen. We all hope that a tragedy never happens to a family, but in reality, sometimes these circumstances do happen. Sometimes a child is primarily with one parent, and the other parent is not in the picture. They don't exercise parenting time. They don't financially support this child. If that parent who has physical custody were to pass away unexpectedly, there might not be orders set in place for how this child is going to transition in their life. According to the law, that child would then go live with the other parent. And that's a tragedy. Not only have they lost a parent, now they're going to be forced to live with a parent that they haven't had contact with for a number of years.
And then also taken out of a household. Maybe they have a step-parent in the household and siblings in the household. That everything they know is going to be taken away from them, basically. Is that what you're saying?
Exactly, Lisa. So that brings me to the idea of talking about step-parent adoptions. There are situations where a step-parent really has become the actual parent for that child, whether it be the other parent is not involved financially or doesn't see the child. The law in Michigan permits step-parents to petition for an adoption of that child. We encourage people, if they do have that situation, that they proceed with going through with those adoptions to avoid circumstances like the one we're talking about today. Because if they didn't file for that adoption, it results with this child, like I mentioned before, living with a parent that maybe they really didn't have much contact with. And really it is in the best interest for that child to stay with the step-parent and their siblings, maybe half-siblings, step-siblings, but the judge's hands are going to be tied because that parent has no standing.
So when the custodial parent and the step parent haven't done that step parent adoption, in that context, if the custodial parent dies, could the step parent do a guardianship, or is there something that could keep the child in the home where the child is while they're working out whether the non-custodial home is even appropriate? I mean, how do we even know it's a fit home?
Lisa, this is very case specific on the guardianships. Every case is extremely different on whether they will be able to fit into the parameters of a guardianship. But the guardianship laws are pretty finite, Lisa, so I always would encourage go with the step-parent adoption route just to be sure that that is what is best for your family. I'm not saying that it's not impossible to file for guardianship, but as I stated, the laws are so strict on standing to file for guardianship that it's best to look at all your options ahead of time to avoid these issues from occurring.
And people don't want to think about tragedies like that. People seem to think that they're invincible, but it is so important that if you have a child, you need to plan ahead. You certainly don't want to end up in a situation like Erica was describing where the parent dies, the biological parent is in California, this child's been in Michigan for their entire life living with their step-parent and step-siblings, and then all of a sudden end up having to go over to California and who knows what type of situation.
Right. Well, you've seen tragedy strike in some of your own cases, Amy, haven't you?
I have, and that's a situation that I feel very strongly about is we see situations where we have two parents and they both clearly love their child. There's no doubt about it. But unfortunately, they're so entrenched in believing that what they think is right for this child is the only way to deal with this situation. And they go to court and they bring out the worst in the other parent. And so you have this lengthy evidentiary hearing in front of the court saying all of this nasty stuff about the other parent. And then in a situation that I'm thinking of, about 1 month after the final hearing date, the mom died. And so here we have two children that have been in the middle of a custody hearing, and then all of a sudden their mother passes away. Another situation I had is where two parents, again, fighting over what's best for a little guy, and both setting forth their positions to the court. And then unfortunately, what happened following that case being finalized, the child passed away. And to me, that is horrible. And that's another reason why parents need to try to work together.
So we've been talking about families that live in different households and tragedy strikes, but what about when we have an intact family and something tragic happens to that family? How do they handle it? What are the things that they have to deal with?
Lisa, that does happen in our cases, and we find that unfortunately a tragedy, whether it be a child dying or maybe a grandparent passing away, a tragedy to a family, and it creates a situation where the parties then lead to getting divorced. That is a large stressor on a family when you have a loss. And so we see that in our practice, that is what really broke up that family, was the death of a child, or maybe it was a child who spent years with a serious illness, and the parties didn't really focus on their marriage. They were focusing on their child, rightfully so, but then they see that their marriage dissolves. So we do want people to know that when you do suffer a tragedy in your family, that you do need to seek out counseling. You do need to understand that your family life is going to restructure, and learn how to build a new family so that it doesn't lead to divorce. We certainly don't want to promote divorce. We know it, in some cases it's inevitable, but tragedies do have a serious effect on families that often lead to a divorce.
So when tragedy does strike a family, for example, if one of the parents passes away, what can a grandparent do if they still want to be involved with their grandchild's life, even though their own child has died?
We have had that obviously in our office before, and the first thing we want to do is encourage the families to have discussions, to try to understand each other's position before you run to the courthouse and file a petition for grandparent rights in order to see your grandchildren. We would hope that the the ex-spouse or ex-partner that is still alive would understand that the children having a bond with their grandparents is beneficial for their children, and it's healthy for the children, and it only helps them, and it's in fact in their best interest. So we would always hope that the grandparents will still be involved in the children's life. Again, you can go to court in that instance and seek grandparent rights, but always sitting down as a family and figuring out what's best for the children always is a better result.
Thank you, Erica. Thank you, Amy, for sharing some thoughts on a very difficult topic today.
Thank you, Lisa.
Thank you, Lisa.
In the Name of Family Law is brought to you by Bailey and Terranova Attorneys at Law. In the Name of Personal Injury Law.
Today I have with me Steve Sinas of the Sinas Dramis Law Firm, and he has two very special guests with him today. Steve, can you tell us who these people are?
Yeah, well, today we're going to talk about police misconduct cases and how those are handled in civil litigation. And there's, a whole lot of misinformation about what goes on with these cases. So I'm happy to have with me Cindy Heenan and Buck Davis from the law firm of the Constitutional Litigation Associates. They're located in downtown Detroit, and we've actually co-counseled a couple police misconduct cases with them, and we're going to talk to the viewers about that today.
So tell us about the law for police misconduct cases.
Yes, the primary statute is 42 United States Code 1983, and that's why it's called 1983 litigation. It's an interesting statute. It's the first civil rights statute ever passed in the United States. It's the Civil Rights Act of 1871, originally known as the Ku Klux Klan Act, because after the Civil War and the Union troops were removed, the Southern aristocracy drummed up the Klan to try to force the minorities and poor whites back into semi-servitude. And so this original statute was aimed at suppressing the Klan. The second thing that's important about it is that it's the only civil rights statute which applies to everybody. It's not based on race or religion or national origin. It's to assert federal control over every local and state official to enforce the Constitution, primarily the Bill of Rights, First Amendment, Fourth Amendment, and 14th Amendment. And so it wasn't used much for almost 100 years, and then it became popular during the civil rights movement that started in the 50s and the 60s down south, and has now grown into a subspecialty in the law.
And within the law, it allows people to pursue damages if the government has violated their constitutional rights.
Right.
Right.
And the Fourth Amendment is the constitutional provision that we're looking to when we talk about these cases, police misconduct cases. The Fourth Amendment protects citizens against unreasonable searches and seizures of their persons, their homes, their papers, and their effects. And in this context, the seizure, we're talking about seizures in most cases. An arrest is a seizure. Being shot by a police officer with a gun or a taser is a seizure. Being grabbed and thrown to the ground or pulled out of your vehicle is a seizure. Or even being told to just stay where you are, but that you are not free to leave, is a seizure. And of course, not all force or all seizures are unreasonable. In this litigation, it's the reasonableness or lack of reasonableness that's the key.
Yeah.
So I understand that you you worked on some significant cases with the Sinas Dramis law firm, and I would really want to hear more about those two cases, the Bletz case and the Guilford case.
Yeah, so I want to first say I have the utmost respect and admiration for police officers and know that the vast majority of them are doing great work and they should be commended for serving our communities in the way they do. However, police officers even tell me that they're happy that this law exists, that there's a way for accountability to exist if constitutional rights are being violated by other police officers. So as far as these two cases go, these were unfortunate, tragic situations involving fatalities. And here is the basic facts of the Bletz case. Mr. Bletz's son had a drunk driving charge, and the police came up to their house, and the son still lived with them at 12 a.m. in the morning, or at midnight, and went to serve a bench warrant on the son. And Mr. Bletz woke up because of all the commotion around the front porch with the dogs barking, and grabbed his handgun and walked down the hall in his underwear. And one of the cops who was standing in the doorway got scared by his presence and shot him, just really within a matter of seconds. And the other cop really didn't justify the other officer's actions. In fact, he kind of waffled in his deposition about whether he thought that was really a reasonable use of force. And obviously the argument is that this poor man who just got up out of his sleep using a lawfully owned firearm shouldn't have been shot in his underwear in his hallway. And then he bled to death in his house. They locked up the wife in the car while he was bleeding. It was just a horrible situation. So, Buck can tell us a little bit more about how that case was actually handled in the courts. Our firm worked hand in hand with their firm. And Buck, why don't you tell a little bit more about that?
You can file a civil rights case in either state court or federal court, but we always file in federal court. Otherwise, you're dealing with a jury from the same jurisdiction as the police that you're suing. And so we think you get a fairer shot at it in federal court. In 1985, the Supreme Court, the government does not like being sued, and therefore they erect every possible barrier. And the Supreme Court decided a doctrine called qualified immunity. That is, unless it was absolutely clear that the action that the officer was undertaking was unconstitutional or illegal, he's entitled to immunity. And then they decided that if the officer filed for qualified immunity and was denied, they could take an interlocutory appeal before trial, because immunity is immunity from suit, not just immunity from trial, which means that almost every case goes to the Sixth Circuit Court of Appeals in Cincinnati. The computer shows I've been there 140 times since 1990, and it means that these cases string out between 3 and 5 years. You have to stand there a long time in order to get to the end, which is one of the reasons that not many people specialize in this particular area of the law.
So in the Bletz case, you had to go to the Sixth Circuit in the middle of the case.
Yes.
And basically earn the right to finalize the case.
Right.
And I think it's settled. You know, before we run out of time, I want to make sure we talk about the Guilford case.
Yeah, so Bletz came back to the trial court after the opinion, and then it settled because they didn't want to face the trial. The Guilford case, similar thing happened in terms of the legal result. It settled while the case was actually pending appeal on the qualified immunity. But what happened with Devin Guilford is that he was driving down a road and he flashed a police officer with his bright lights, thinking the officer had his bright lights on. The officer pulled him over for doing that, and then they had a verbal altercation with one another. It's fair to say that Devin was not really complying with the officer verbally, but it resulted in the officer removing him from the car, putting him down on the road, then tasing him. And then the issue that came up in the case is what happened after he was tased. The officer said Devin charged him, and then the officer then shot him 7 times. And there was discrepancies enough for the case to settle prior to trial. And that's
very
how that got
tragic
resolved.
cases.
Yeah.
Thank you for sharing them with us today.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Criminal Defense.
Hello, we're here with Takura Nyamfukudza and Mary Chartier to talk about self-defense. So I heard you guys had a really interesting criminal case where you used the defense of self-defense successfully.
We did.
In a criminal trial. Can you tell us about that?
We can. So our client shot his ex in the head during a custody exchange, and they met in a public place, which the government tried to characterize as a remote location. It was a gas station that was no longer operative. And there were witnesses who were going into a restaurant who testified that our self-defense claim, or the client's self-defense claim, was not accurate because he had said that he was being stabbed with a knife and he shot her with a gun. But we were able to prove that those witnesses were mistaken, and Takura did that about what they claimed that they saw, and ultimately the client was acquitted. The jury felt so strongly that he had been acting in self-defense when he pulled out his gun and shot his ex.
Well, tell us about then what you have to show to prove self-defense. How does it work?
So you have to show that in that moment the client reasonably believed that his life was in danger, or that a sexual assault was about to occur, which wasn't the case here, or that the client was at risk of great bodily harm. And we were able to show that he had been stabbed repeatedly by the woman who he shot. There was a knife found at the scene. Witnesses said, you want to fill us in on that?
Oh my goodness gracious. So this lady saved the day, right? She came and the child was there at the child exchange, right? So this witness heard the child crying, opened the door to take the child out and run back to the restaurant. And she says as soon as she opened the door, she saw the knife fall out of our client's car and the pillow fall on top of it. So if you believe her, he stabbed himself, brought the knife to the child exchange, and then he secreted it and shot her.
But what we were able to show was her claim that she saw these things from where she was located and other witnesses as well just wasn't possible. So first of all, they said that they'd heard an argument. We went to the scene. We put cars exactly where the cars were. I have an incredibly loud voice. I was hollering at the top of my lungs. They couldn't hear anything. We had people. There was no way that you could hear it. And the knife was actually bent because the client had been stabbed so forcefully by the woman, and the pillow was not in the location that the woman had claimed. So we were really able to show that he acted in self-defense. One of the most important witnesses was the police officer.
Oh, absolutely.
Remember?
Yes, yes.
So when he got on the stand, he said, talked about what, sort of what the standard was in terms of investigating and what they had done. The government kept trying to claim that the knife wasn't really a knife. It was more like, just a little knife. That's what they kept saying, not really a harmful weapon. Well, we asked if the client had been taken into custody, which he was, and had this knife on him, would you have allowed him to go into custody with it? And his response was?
Absolutely not.
And why not?
Because he could kill somebody with it.
Right. He said because it's a weapon. So it really gutted the government's claim that even if this knife had been present in the woman's hand, that it wasn't really a weapon. And then we asked, if you had been stabbed, if someone was coming at you with this item, what would you have done? And he said?
Keep shooting until I eliminate the threat.
Right.
Wow.
Which was so forceful. We didn't need an expert. We were able to use their police officer as essentially our expert, because our client only shot until the threat was eliminated. He had other bullets, right? He had other bullets in his gun.
Right. So in a criminal case, the prosecution has to prove their case beyond a reasonable doubt in order to get a conviction. Does that change? Do the burdens change at all when you're trying to show that defense has the defense of self-defense?
When you have a self-defense or defense of others claim, you have to put what's called prima facie evidence on. So we just have to put some evidence that this is our defense. Client testified in this situation, and he did so, I think, extremely sincerely and genuinely. Once that evidence is presented, and it doesn't always have to be presented through the client, then the government has the burden to disprove self-defense or defense of others by a reasonable doubt.
So we've been talking about the use of deadly force. Let's switch gears and talk about the use of non-deadly force in self-defense. Is there a difference?
There is. And there's a recent Court of Appeals case called People versus Raw, R.A., that came out of Detroit. The woman pulled out a weapon that was unloaded because she believed that she and her child were in imminent danger. And she used non-deadly force to try and scare the person away. She was convicted. And the prison sentence for that for her was 2 years. But the court held that in abeyance while she had fantastic lawyers. They appealed that to the Court of Appeals. The Court of Appeals said the wrong standard had been used. What the jury had been told was she had to be afraid of, same as our client, death, sexual assault, or great bodily harm. But that is not the standard. That's the standard when potentially deadly force is used. For non-deadly force, a gun that's not even loaded, that's not the standard. And so her conviction was reversed.
Well, I'm curious now, if she had a loaded gun but didn't shoot it, would that be the use of non-deadly force or deadly force?
Well, that's going to be the twist, right?
Yeah.
So there's not a case that we're aware
Not
of
yet.
on that, right? But in my opinion, I think that's still non-deadly force.
I agree.
Because it's a gun that's loaded, but she hasn't pulled the trigger. It's not like she fired it at someone or whoever that person would be.
And I think that would be no different than someone pulling out a baseball bat, for example. So you could hit somebody in the leg with that, and while it may hurt, they might have an owie. Again, that's not deadly force.
But if you bash them in the head with it, it could be deadly
There you
force.
have it. So very fact-specific.
Wow.
You see a lot of self-defense cases, especially in college towns or in bar fights. Those happen a lot. We've handled a lot of, a lot of assault cases where there's what we call a mutual affray, a couple of guys getting into a fight, or sometimes a couple of women getting into a fight, and the argument is self-defense.
So a couple of the cases I've heard about are somebody's pounding at your door in the middle of the night, and you have a gun and you shoot, like maybe shoot high because you don't want to like kill anybody, and it turns out the person's really tall and gets shot in the head and dies. So what do you have to say about a case like that where you can't even see who the person is, but you are in fear of your life?
Well, there was a conviction actually out of Detroit, I believe, on somewhat similar facts on that. I mean, you don't have a duty to retreat when you're in your own home.
Okay.
So you don't have to try and run away or anything like that. And you do have the right to defend yourself when you're in your home.
Right.
The issue is always on these cases, they're so fact specific.
Right.
So was it, a Girl Scout in the middle of the day, or was it 2 o'clock in the morning?
Right.
And all of it is, was the person reasonable in his or her belief? That's what it really boils down to.
Right, and so the example, and there was actually a case in Texas like this where crazed person in the middle of the night is banging on the door, and it was very scary. And so when you shoot, like the context, you said,
Right.
not a Girl Scout in the middle of the day, it's different context. So,
Right.
Oh my gosh, this has been so interesting. Thank you so much.
Thanks, Lisa. If anyone is interested in learning more about this issue or other issues related to criminal defense and constitutional law, check us out. We are Constitutional Defenders. We have a podcast on cndefenders.com or iTunes or any other site that hosts podcasts.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza PLC.
Well, we really had a heavy episode today. Thank you all for sharing your stories. Do you have any final thoughts about the tragic situations that your clients had to encounter and overcome?
Well, I think about it in terms of being a personal injury lawyer. We deal with tragedy all the time, and sometimes that tragedy is even greater given the circumstances. So when I think about these police misconduct cases, I know that the police officers out there generally are doing their job, and most of them do a great job at it, and they're so courageous in doing that. But in those two cases that we talked about, the Blitz case and the Guilford case, tragedy was because life was lost, but also, the police officer involved didn't really meet their duties, didn't obviously satisfy their obligations under the Constitution. I found that to be another added element of tragedy to those cases.
And of course, actually for both of you, we talked about family situations that can result in tragedy. Takura, I mean, I know you do criminal defense law. It was a little bit unique just because it tied into the family law context with the case that you worked on, the self-defense case.
Indeed. And even though it's been many years now since the incident occurred and ultimately we prevailed at trial, still both sides of the family are still being impacted by what it is that brought us into their lives. But that case, like many others though, but especially this one, gave me great confidence in the jury system. They were not easy facts, but they listened and they applied the burden of proof. But yeah, those children are still being impacted today and will be for the rest of their lives, I think.
And I think that happens with every party in these situations. As a tragic event happens, but we see how that it affects the family members, the dynamics of the family for a long time after the tragedy occurs.
Right. So, there's a lot of these cases involve somebody dying or being seriously injured. And for the two of you, really, it was about how those situations impact the children for a long time afterwards. And in the family law courts, even though it started off as a criminal case. And Steve, we had families impacted as well with the deaths of those innocent people.
Yeah, and when you think about physical injuries within a family, there could be the personal injury case that arises from it. It could result in a criminal case. It could result in a domestic dispute that leads to family law matters. So obviously when people's health is compromised and the family then is affected by that, it has the potential to bring up all kinds of legal issues.
Well, thank you for sharing with us today, and everybody should stay tuned for our next episode. Will be a little bit more lighthearted to make up for the heavy topic we had today. Thank you so much, all of you.
Thank you, Lisa.
Thanks.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.